Your dual citizenship status is being discussed in Washington right now. And while no new laws have taken effect, there's a proposed bill that could change everything if it passes. For millions of dual citizens in the United States and Americans holding citizenship in other countries, a proposal called the Exclusive Citizenship Act of 2025 has sparked intense debate about the future of dual nationality in America. While this bill is not currently law and nothing has changed yet, if you're a dual citizen or planning to become one, understanding what's actually being proposed versus what the current rules are could help you make informed decisions about your future. Welcome to U.S. Visa Info, your essential resource for understanding American immigration law, citizenship regulations, and visa requirements. I'm here to explain the real status of dual citizenship in the United States today, break down what the proposed Exclusive Citizenship Act would actually do if it passes, clarify the existing rules that are already in effect, and separate fact from fiction about dual citizenship obligations. Whether you hold American citizenship along with another country's passport, or you're a foreign national with dual citizenship applying for U.S. immigration benefits, it's crucial to understand what's real versus what's just proposed. So let's get straight into the facts. Current status. What's actually happening? As of January 2026, dual citizenship remains completely legal in the United States. Despite some alarming claims you might see online, no new dual citizenship laws took effect in January 2026, and the U.S. government has not implemented new tracking systems, mandatory disclosure requirements, or enhanced screening procedures this month. What has happened is that a proposed bill was introduced in Congress in December 2025, but introducing a bill is very different from passing a law. The proposed legislation, called the Exclusive Citizenship Act of 2025, was introduced by Senator Bernie Moreno of Ohio. This bill proposes that Americans would have to choose between U.S. citizenship and foreign citizenship, but as of now, this is just a proposal. It has not been debated, voted on, or enacted. The legislative process for any bill involves multiple steps including committee review, debate in both the House and Senate, and presidential signature. Most bills introduced in Congress never become law. The reality is that American dual citizenship policy has been stable for decades. The United States does not require citizens to choose only one nationality, does not prohibit holding multiple passports, and recognizes that millions of Americans maintain ties to other countries through citizenship. This has been the case for many years and remains true today. Understanding current dual citizenship rules. Let's clarify what the actual rules are right now. Not proposed changes, but what's been in effect for years. First, the United States allows dual citizenship. When you naturalize as a U.S. citizen, you take an oath of allegiance, but the U.S. government does not require you to formally renounce your previous citizenship. Many countries allow their citizens to naturalize elsewhere while keeping their original nationality. Some countries do not permit dual citizenship under their own laws, meaning if you become a U.S. citizen, you may automatically lose your original citizenship according to that country's rules, not U.S. rules. Second, when you apply for or renew a U.S. passport, there is a question asking if you hold citizenship in another country. You should answer this honestly, but there is no cross-referencing system that automatically checks your answer against foreign government databases. The question exists primarily for informational purposes and to help the State Department assist you if you encounter problems abroad. Third, when entering the United States, U.S. citizens must present their U.S. passport. Immigration officers may ask about other citizenships during routine screening, but there is no special January 2026 enhanced screening program. Standard procedures that have existed for years remain in place. If you're a dual citizen, you should use your U.S. passport when entering the United States, which has always been the requirement. Fourth, regarding taxes, the United States does tax citizens on worldwide income, regardless of where they live. This has been true for decades. The Foreign Account Tax Compliance Act, or FATCA, requires U.S. taxpayers to report foreign financial accounts exceeding certain thresholds. For 2026, you must file a report of foreign bank and financial accounts, known as FBAR, if the aggregate value of your foreign accounts exceeds $10,000 at any point during the year. These are existing requirements, not new January 2026 rules. What the proposed bill would actually do. Now let's examine what the Exclusive Citizenship Act of 2025 proposes, keeping in mind this is not current law. If enacted, the bill would require U.S. citizens to renounce any foreign citizenships they hold. The proposal would give current dual citizens a period of time to choose whether to keep U.S. citizenship or their foreign citizenship. If you chose to remain a U.S. citizen, you would need to formally renounce your other citizenship according to that country's procedures. The bill proposes that future naturalization applicants would be required to renounce their previous citizenship as a condition of becoming American. This would be a significant change from current practice. The legislation suggests that U.S. citizens who acquire or maintain foreign citizenship after the law takes effect could potentially lose their U.S. citizenship, though the specific enforcement mechanisms are not entirely clear from the proposal. Importantly, the bill includes exceptions for certain situations, though the exact scope of these exceptions would need to be defined if the bill advances. The proposal has generated significant controversy and faces substantial opposition from immigration advocates, civil liberties organizations, and communities with strong ties to other countries. Security clearances and government employment. One area where dual citizenship does currently matter is security clearances and certain government positions. This isn't new for 2026, but it's worth understanding. When you apply for a security clearance, investigators consider all aspects of your background, including foreign citizenship, foreign contacts, and foreign financial interests. Holding dual citizenship is not an automatic disqualification, but it is a factor that's carefully evaluated. For access to highly sensitive, classified information, you may be asked to take mitigating actions regarding your foreign citizenship. This has been the policy for many years. What constitutes adequate mitigation depends on the specific circumstances, including which country's citizenship you hold, whether you actively use that citizenship, and the level of clearance you're seeking. Some positions may require you to renounce foreign citizenship, while others may simply require you to demonstrate that your foreign ties don't create conflicts of interest or vulnerability to foreign influence. It's important to understand that these security clearance considerations have existed for decades and are not new policies being implemented in 2026. The standards are regularly reviewed and updated, but the basic framework of evaluating foreign connections has been consistent. Tax reporting. What you actually need to know. The tax obligations for dual citizens are real and important, but they're not new for 2026. Let's clarify what's actually required. If you're a U.S. citizen or resident alien, you must report your worldwide income to the IRS, regardless of where you live. This applies whether you have one citizenship or multiple citizenships. The FBAR filing requirement applies if you have financial interest in or signature authority over foreign financial accounts, with an aggregate value exceeding $10,000. This is filed separately from your tax return using FinCEN Form 114. FATCA may also require you to file Form 8938 with your tax return if you have specified foreign financial assets above certain thresholds, which vary based on your filing status and whether you live in the U.S. or abroad. The penalties for failing to file required reports can be significant. Non-willful violations of FBAR requirements can result in penalties up to $10,000 per violation. Willful violations can result in the greater of $100,000 or 50% of the account balance. These penalties have existed since these reporting requirements were established, not starting in January 2026. Many dual citizens who inherited citizenship through ancestry may not realize they're considered citizens of another country. For example, if you have Italian, Irish, or Polish ancestry, you might be eligible for citizenship in those countries even if you've never applied. However, eligibility for citizenship is different from actually holding citizenship. Generally, you need to take some action to claim citizenship, such as applying for a passport or registering with that country. Simply being eligible doesn't automatically make you a citizen or trigger reporting requirements. Passports and international travel. Current rules for dual citizens traveling internationally are straightforward and haven't changed. When you enter the United States, you must use your U.S. passport if you're a U.S. citizen. When you enter your other country of citizenship, you may be required to use that country's passport according to their rules. This is standard practice and has been for many years. Some countries require their citizens to enter and exit using their national passport. For example, if you're a dual US-Canadian citizen, Canada requires you to present your Canadian passport when entering Canada. The US requires you to present your US passport when entering the United States. This means you might carry both passports when traveling between these countries, which is perfectly legal and normal. There is no rule against using different passports for different legs of your journey, as long as you comply with each country's entry requirements and you're honest about your citizenship status when asked. Using multiple passports strategically isn't illegal, though you should always provide truthful answers to immigration officers and on official forms. Children and dual citizenship. Children born to dual citizen parents or born in circumstances that grant them multiple citizenships face some special considerations. But again, these aren't new rules for 2026. A child born in the United States automatically acquires U.S. citizenship, regardless of the parent's citizenship status. If the child also acquires citizenship in another country through descent from a parent or through the laws of another country, the child becomes a dual citizen at birth. When applying for a U.S. passport for a child, you're asked about other citizenships the child holds. You should answer honestly, but the application process is the same whether the child has one citizenship or multiple citizenships. The U.S. government doesn't prevent children from holding dual citizenship. Some countries do have mandatory military service requirements that could apply to your child when they reach a certain age. For example, Israel, South Korea, and several other countries require citizens to perform military service. If your child holds citizenship in one of these countries, they may be subject to these requirements when they reach the appropriate age. This is governed by the other country's laws, not U.S. law. The United States doesn't prohibit dual citizens from serving in foreign militaries, though serving in a foreign military can potentially affect security clearance eligibility later in life. Naturalized citizens and foreign citizenship. When you naturalize as a U.S. citizen, you take an oath of allegiance that includes language about renouncing foreign allegiances. The specific wording states that you absolutely and entirely renounce and abjure all allegiance and fidelity to any foreign prince, potentate, state, or sovereignty. However, U.S. courts and the State Department have interpreted this as renouncing political allegiance rather than requiring you to formally terminate your legal citizenship in another country. This interpretation has been consistent for decades. Naturalized U.S. citizens are permitted to maintain their original citizenship for purposes of travel, family connections, property ownership, and other practical matters. You can renew your foreign passport, visit your country of origin, and maintain ties there without jeopardizing your U.S. citizenship under current law. However, there are some actions that could potentially raise questions about your allegiance. Serving in a foreign military, especially in a combat role against U.S. interests, could be problematic. Accepting a policy-level position in a foreign government could also raise concerns. Voting in foreign elections is generally not considered problematic for U.S. citizenship purposes, though it's worth noting that exercising political rights in another country could be relevant if you ever apply for a security clearance. Denaturalization, the process of revoking someone's U.S. citizenship, is extremely rare and requires proof that citizenship was obtained fraudulently or that the person concealed material facts during the naturalization process. Simply maintaining your original citizenship after naturalizing does not constitute grounds for denaturalization under current law. Immigration petitions and dual citizenship. If you're a U.S. citizen petitioning to bring family members to the United States, your dual citizenship generally doesn't affect the process. Family-based immigration petitions are evaluated based on the relationship between the petitioner and the beneficiary, the eligibility criteria for the specific visa category, and standard background checks. However, if you hold citizenship in a country that the State Department has designated as a state sponsor of terrorism, or if you're petitioning for someone from such a country, the petition may receive additional scrutiny. This is standard security screening that applies regardless of whether you're a dual citizen. The goal is to ensure that individuals entering the United States don't pose security risks. Current state sponsors of terrorism designated by the State Department include Cuba, North Korea, Iran, and Syria. If you have connections to these countries, whether through citizenship, family ties, or extended residence, your immigration petitions may take longer to process due to enhanced background checks. This isn't a new policy for 2026, but has been standard practice for national security purposes. Professional licensing and dual citizenship. In most cases, dual citizenship doesn't affect professional licensing in the United States. Attorneys, doctors, engineers, and other licensed professionals who hold multiple citizenships can practice their professions without restriction. State licensing boards focus on education, examination, experience, and ethical standards rather than citizenship status. There are some exceptions in fields involving national security or sensitive government work. Defense contractors, intelligence community personnel, and some positions in critical infrastructure may face restrictions based on foreign citizenship or foreign connections. These restrictions are typically tied to security clearance requirements or specific regulatory frameworks for sensitive industries. If you work in one of these fields, dual citizenship might limit your eligibility for certain positions or require you to take mitigating actions. However, these are specific circumstances rather than blanket restrictions on dual citizens across all professions. What should you actually do? Given the current state of affairs, what action should dual citizens take? First, ensure you're complying with existing tax reporting requirements. If you have foreign financial accounts exceeding the FBAR threshold, make sure you're filing the required reports. If you've fallen behind on these requirements, the IRS has streamlined procedures for taxpayers to come into compliance. Second, when filling out government forms, answer questions about citizenship honestly. If asked whether you hold citizenship in another country, provide accurate information. There's no penalty for being a dual citizen, but providing false information on government forms can create serious problems. Third, if you work in a field requiring security clearances or government contracts, be proactive about disclosing your foreign citizenship and connections. Security clearance investigators value honesty and transparency. Attempting to hide dual citizenship is far more problematic than openly acknowledging it and explaining your circumstances. Fourth, keep informed about the status of the proposed Exclusive Citizenship Act and any other legislation affecting dual citizenship. If this bill advances through Congress, there will be opportunities for public comment and debate. Understanding the proposal and how it might affect you can help you make informed decisions about whether to contact your representatives or take other actions. Fifth, if you have questions about how dual citizenship affects your specific situation, consider consulting with an immigration attorney. Immigration law is complex, and individual circumstances vary significantly. Professional legal advice can help you understand your rights and obligations. Separating fact from fiction. In an era of rapid information sharing, it's easy for misinformation about immigration and citizenship to spread quickly. You may encounter alarming claims about new requirements, deadlines, or enforcement actions. When you see such claims, consider the source carefully. Is the information coming from an official government website? Has it been reported by mainstream news organizations? Does it cite specific laws or regulations you can verify? The official sources for accurate information about U.S. citizenship and immigration include the State Department website, the Department of Homeland Security, U.S. Citizenship and Immigration Services, and Internal Revenue Service publications. These agencies publish clear information about actual requirements and policy changes. Be skeptical of claims that create urgency or panic, especially those involving specific near-term deadlines for compliance with supposed new requirements. Real government policy changes are typically announced well in advance, with clear implementation timelines and official guidance. Looking forward, the debate about dual citizenship in America reflects broader questions about national identity, globalization, and the meaning of citizenship in an interconnected world. The United States has historically been more accepting of dual citizenship than many other countries, recognizing that in a nation built by immigrants, maintaining connections to ancestral homelands is natural and valuable. Whether the Exclusive Citizenship Act or similar legislation will advance remains to be seen. Such a significant change in policy would face numerous legal, practical, and diplomatic challenges. Many other countries allow dual citizenship, and requiring Americans to renounce foreign citizenships could create reciprocal demands from those countries affecting Americans living abroad. For now, dual citizenship remains legal, and millions of Americans successfully navigate life with multiple nationalities. By understanding the actual requirements, staying compliant with existing rules, and remaining informed about potential changes, dual citizens can protect their status and make informed decisions about their futures.